Vice President.
Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the Vice President.
Honorable Senators, I have granted leave of absence to Senator Hazel Thompson-Aye and to Senator Tahaka Obika, both of whom are out of the country. Honorable Senators, I have received the following correspondence from Her Excellency the President, Paula May Weeks, ORTT. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Paula May Weeks, ORTT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces, to Ms. Zola L. Phillips. Whereas Senator Hazel Thompson-Aye is incapable of performing her duties as a senator by reason of her absence from Trinidad and Tobago, now therefore I, Paula May Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)A and Section 44(4)C of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Zola L. Phillips, to be temporarily a member of the Senate with effect from the 19th of February 2019 and continuing during the absence from Trinidad and Tobago of the said Senator Hazel Thompson-Aye, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 15th day of February 2019. Honorable Senators, Senators are required to take the oath.
I, Zola Phillips, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Honorable Senators, I'm just currently waiting another instrument to come in, so I crave your indulgence to revert to this item once we receive that instrument.
Papers.
Minister in the Ministry of Finance.
Thank you, Mr. Vice President. Mr. Vice President, I have the honor to lay on the table the following paper as listed on the order paper in the name of the Minister of Finance. The consolidated audited financial statements of First Citizens Holdings Limited and its subsidiaries for the financial year ended September 30, 2018.
Reports from committees.
Senator the Honorable Kazim Hussain.
Mr. Vice President, I have the honor to lay on the table the following report as listed on the order paper in the name of Senator the Honorable Kazim Hussain. The 10th report of the Joint Select Committee on Human Rights, Equality and Diversity, 4th session, 2018-2019, 11th Parliament on the treatment of detainees at the Immigration Detention Center.
Urgent questions.
Mr. Vice President, I crave your indulgence. The Minister of National Security is on his way. He will be here shortly, so I will request that you stand on this question for a short while, and we move on to question number 2.
Question number 1 on urgent questions would be stood down until the arrival of the Minister of National Security, who we have been advised is on his way. So we'll move on to question 2 on the urgent question. Senator C. Prasad.
Can the Minister indicate how will the recent blacklisting of Trinidad and Tobago by the European Commission impact day-to-day banking transactions with European banks?
Minister of Finance.
Thank you. Thank you, Mr. Vice President. I'm sorry. Oh, I'm sorry. I'm so happy that you're here. I didn't realize he was here.
Robert, you could have tell her. Thank you very much, Mr. Vice President. Mr. Vice President, just let me indicate that the U.S. Treasury Department has scolded the European Union for including U.S. territories on a list of tax havens or areas where there is money laundering around the world, and has told American banks to ignore EU directives in a very unusual technocratic spat that shows continued friction between Washington and Brussels. The Attorney General has issued a statement on February the 15th last week, and I read from that statement that we wholeheartedly agree with the analysis of the United States, which laid 4 compelling reasons for the rejection of the European Commission's publication. Namely, first, the Commission's process did not include a sufficiently in-depth review necessary to conduct an assessment related to such a serious and consequential issue. Second, the Commission provided affected jurisdictions with only a cursory basis for its determination. Third, the Commission notified affected jurisdictions that they would be included on the list only days before issuance. Fourth, the Commission failed to provide affected jurisdictions with any meaningful opportunity to challenge their inclusion or otherwise address issues identified by the Commission. Those are the words of the United States Treasury, with whom we wholeheartedly agree. The European Union has arbitrarily and unilaterally included us and the United States territories on this so-called blacklist. We do not agree.
Senator Mark.
Mr. Vice President, can the Honourable Minister indicate whether those objections, as outlined by him, in sync with the Treasury Department of the United States, have been formally committed in writing to the European Commission?
Minister of Finance.
And thank you, Vice President. I omitted to deal directly with the core of the question asked by Senator Sipasad. We have no reports of any impact on Trinidad banks and their dealings with European banks at this point in time. We continue to monitor that situation. We do intend to communicate with the European Union and object in the strongest possible terms, just like the US has done.
Senator Sipas, you done? Senator Timal.
Honourable Minister, are there any specific measures that we intend to take to get our name removed out of that blacklist?
Minister of Finance.
This so-called blacklist came out of the blue. We are still studying it. As the United States has said, it is completely arbitrary, and countries were not informed of this. It appears that the European Union is now developing its own criteria in addition to FATF criteria, and in addition to Global Forum criteria. The European Union is now developing its own criteria. So we would need to look at this very carefully and determine how we deal with this. But the first thing we will do is to make representation at the highest level and object in the strongest possible terms to this arbitrary event.
Senator Mark, question 1 on the urgent question notice.
Yeah. Question 1 to the Minister of National Security. In light of statements made by the Chief Immigration Officer that exercises to detain illegal immigrants have been halted due to a lack of capacity at the Immigration Detention Center, IDC, can the Minister indicate what measures are being taken to address this issue?
Minister of National Security.
Thank you very much, Mr. Vice President. Mr. Vice President, as was put out in a statement from the Ministry of National Security on Sunday, we continue to detain illegal immigrants. In fact, up to yesterday, I believe there were 20 illegal immigrants detained. And as I've indicated in that statement from the Ministry of National Security, there is an interagency task force set up, which includes the Prison Service of Trinidad and Tobago. And we're looking at utilizing some of the empty prison facilities. For example, that prison facility, the warehouse that was purchased under the former administration for hundreds of millions of dollars, that wasn't sufficient to be a full-scale prison. We're looking at utilizing that now for the detention of illegal immigrants. So there is no crisis, this continued cry for there to be a crisis. There is none. Immigration continues to do its work along with the Trinidad and Tobago Police Service and other agencies in national security.
Supplemental.
Could the Honourable Minister indicate what would have prompted the Chief Immigration Officer to make such a statement at a JSC meeting in the full view of the public, given the fact that the Minister has indicated there is no such crisis? Why would a Chief Immigration Officer communicate that information in the public on this matter? Can the Minister clear that first, Mr. Chairman?
Minister of National Security.
Thank you very much. It would be impossible for me to put myself in the shoes of the Chief Immigration Officer and the person who's alleged to have made the statement. What I can say is the Immigration Detention Center is very close to capacity in terms of the number of people that it can hold. So if that is what the Chief Immigration Officer was referring to, that there's a capacity issue, yes, there is a capacity issue. As I've said and as I've indicated, we are currently dealing with that situation by utilizing other facilities. So for example, right now, illegal immigrants who were picked up yesterday would be housed at police stations and these types of things. And there is a process that they have to go through before final determination.
Senator Mark, supplemental.
Can the Honourable Minister indicate what time frame does he envision for the facility, the so-called warehouse facility that he mentioned? What time frame does he anticipate for that facility to be up and running so that illegal immigrants can be removed from police stations and placed in this new detention center that he has outlined? Madam
Minister of National Security.
Thank you very much, Mr. Vice President. Mr. Vice President, I have asked that it be done in the shortest possible time frame. The warehouse that was purchased by the UNC for hundreds of millions of dollars is in a position that it can house persons. It needs to be declared as a detention center by me as Minister of National Security, and I've asked that they put all of the arrangements in place in the shortest possible time frame so it can be so utilized to give the taxpayers value for money that was wasted previously.
Questions on notice, questions for oral answer.
Leader of Government Business.
Thank you very much, Mr. Vice President. Mr. Vice President, Government, please turn on that we'll be answering all questions on the order paper.
Senator Mark.
Thank you, Mr. Vice President. Question number 74 to the Minister of Public Utilities.
Minister of Public Utilities.
Mr. Vice President, arising out of the restructuring of the telecommunications services of Trinidad and Tobago, a total of 631 employees have been separated from the organization as at the 14th of December 2018, inclusive of 77 workers who took voluntary separation.
Senator Mark, supplemental.
Yeah. Mr. Vice President, can the Minister indicate to the Senate what were the elements that informed the telecommunications services of TNT in its restructuring exercise that would have resulted in the severing of 631 workers? Can you share with this Honorable Senate, through you, Mr. Vice President, the elements that made up this restructuring exercise?
Minister of Public Utilities.
Mr. Vice President, the telecommunications, this restructuring exercise is part of a strategic plan that was put forward by the telecommunications company and with a view of trying to save the organization from bankruptcy by 2021. Based on the profitability trends of the organization needed to be restructured in a manner so that it could save the 1,300 jobs that were remaining in the organization. This is only one aspect of that exercise, the whole digitalization exercise and the improvement of the services of the telecommunication company to be able to better execute their mandate for Trinidad and Tobago is also part of the restructuring exercise of the company. But I reiterate, this was an attempt to save the company from bankruptcy based on where it was heading, with a $300 million, over $50 million loss in the first 6 months of the operations, and earmarked based on projections that were also audited by some of our accounting firms that showed that the organization by 2021, if it continued as its present trajectory in its present form, the organization would have been bankrupt.
Senator Mark.
Can I ask the Honourable Minister whether the recent scandals involving corruption at the TSTT, involving hundreds of millions of dollars, contributed in any way to the so-called bankruptcy claim that the Honourable Minister has made, Mr. Vice President? Can he share with us whether these activities that were fully exposed in the newspapers contributed in any way to the possible bankruptcy that you have mentioned?
I will not allow that question. Next supplemental, Senator Mark.
Mr. Vice President, the Honourable Minister mentioned digitalization of the services as part of the whole restructuring exercise. Can the Honourable Minister share with us what and within what time period he anticipates this element to kick in to make this particular agency and company more efficient in the context of service to the population of TNT?
Minister of Public Utilities.
Mr. Vice President, this, as I said, was part of the strategic plan. It's an ongoing exercise. It has actually already started to kick in with the removal, with the launching of the company's Zero Copper initiative, which is all part of the restructuring exercise, whereby copper as it presently exists as the main medium is one that carries the information very slow and prevents people from being able to get the speed of the information that comes to them via their broadband services is not as efficient. And therefore, that exercise is presently in place, and I expect that the members of the public have already started to benefit from the restructuring exercise by the improved service, both from a quality and the number of people who now have access to broadband services throughout the country. And this will continue up until at least 2020, 2021.
Senator Mark.
Mr. Vice President, the Honourable Minister did indicate that some 77 individuals at the managerial level were severed. Can the Honourable Minister indicate whether he's satisfied that the top heavy management structure of this organization needs to be further restructured to make this organization more efficient, more effective in the delivery of services to the people of Trinidad and Tobago?
Minister of Public Utilities.
Mr. Vice President, I didn't, just as a point of correction, and I will repeat what I said. I said there were 631 employees that were separated, inclusive of 77 workers who took voluntary separation. I never said that those individuals took voluntary separation were at the top level. That being said, I think when you look at the percentages at the top, we would recognize that I think the new executive management team at the top of TSTT has been reduced from, or it's potentially expected to be reduced from a span of around 18 to a span of around 10. So therefore, the largest drop in the amount of individuals happened at that particular level of the organization. I am also confident that the steps that the organization is taking in putting themselves or right-sizing the organization and also improving the technology is the right step towards making the organization profitable going forward. And as I said, saving 1,300 jobs in the process.
Next question on the order paper, Senator Mark.
Question number 75 to the Minister of Public Utilities.
Minister of Public Utilities.
Madam President, so Mr. Vice President, sorry, Mr. Vice President, the compensation package of TSTT CEO and Vice President of Human Resource / Industrial Relations and Corporate Support Services are consistent with current executive remuneration packages for similar scale telecommunication companies operating in Trinidad and Tobago. The CEO of TSTT Services receives the following monthly remuneration package: a salary of $180,000, housing allowance of $15,000, entertainment allowance of $5,000, a company-maintained car, medical coverage consistent with the company's overall medical plan. The Vice President of Human Resource / Industrial Relations and Corporate Services receives the following monthly remuneration package: a salary of $105,000, housing allowance of $7,000, entertainment allowance of $3,000, a company-maintained car, and a medical coverage consistent with the company's overall medical plan.
Supplemental?
Yeah, can I ask the Honourable Minister whether these executive high-ranking personnel also receive on an annual basis bonuses?
Minister of Public Utilities.
I am not in a position to answer that explicitly at this point in time. This is what was presented to me.
Senator Mark, supplemental.
But are you aware, as the line minister, who ought to be fully conscious of the operations of this company, that these high-ranking executive personnel also receive on a yearly basis very handsome bonuses, even in a loss-making company?
Senator Mark, you're asking a question?
I'm asking Mr. Vice President.
Pose it as a question.
I'm asking him, Mr. Vice President, I'm asking the Honorable Minister that is, whether he's aware or he ought to be aware, Mr. Vice President, if I were line minister, I would be aware that these top-ranking personnel have, in fact, been receiving very lucrative bonuses in a company that has been loss-making and has retrenched close to 600 workers.
Senator Mark, the question, you've asked the question, but what you're doing now is you're rambling on.
No.
So you're asking the question, and I don't want to paraphrase, you've asked your question. Okay. So just tighten it up, reiterate the question quickly for the Minister of Public Utilities. There's no need to add on to it. Just ask the question.
Okay. Mr. Vice President, can the Honorable Minister indicate whether he is aware that these top-ranking personnel at TSTT that he has just outlined in terms of terms and conditions are also in receipt of hefty bonuses on an annual basis in a loss-making enterprise like TSTT?
Right, and I won't allow that question. Senator Mark, next supplemental.
Mr. Vice President, can the minister indicate whether these very lucrative packages were approved by the Cabinet of the Republic of Trinidad and Tobago or the board or both?
Minister of Public Utilities.
Mr. Vice President, these salaries were definitely approved by the board of TSTT. The cabinet does not get themselves involved in this particular matter, and these are the salaries that have existed in TSTT for these positions, not only now but in the past. I dare say that the salary that is now being paid to the CEO represents close to 50% than what was paid previously at another time between 2010 and 2015 when there were foreigners that were actually manning those particular positions.
Senator Mark.
Can I ask the Honorable Minister through you, when can we expect further increases in these terms and conditions for these officers in this so-called loss-making company that was on the brink of bankruptcy? Can you advise us through the Honorable President as to when or how often these personnel receive increases? Is it annually, biannually, or every 3 years? Can you share with this Honorable House?
I won't allow that question. Senator Mark, next question on the order paper.
Yes, Mr. Vice President, question number 76 to the Honorable Minister of Public Utilities.
Minister of Public Utilities.
Mr. Vice President, the quantum of money owed to TSTT for CCTV services provided to the Ministry of National Security is not agreed. The matter is under review and is currently the subject of negotiations. I expect this matter will be settled as expeditiously as possible.
Senator Mark.
Mr. Vice President, can the Honorable Minister, as a line minister with responsibility for TSTT, inform this House how long has this outstanding payment that has not been agreed upon how long has this amount been outstanding to the company that is TSTT by the government of the Republic of Trinidad and Tobago, Mr. Vice President?
Minister of Public Utilities.
Mr. Vice President, at this point in time, I could tell you that somewhere in the vicinity of over 6 months, that negotiations have been in place between the Ministry of National Security and TSTT on this matter. As for the exact date of the time that it has been outstanding, I will not be able to give an exact answer. But I know that they have been in discussions between both of them to reconcile the service that has been provided for the past 6 months.
Senator Mark.
Mr. Vice President, can the Honorable Minister indicate to this Honorable Senate how this close to $500 million owed to the Telecommunication Authority by the government of Trinidad and Tobago has impacted, Mr. Vice President, on the TSTT decision to retrench, send home, dismiss, fired 131 workers. Can you tell us if there's a connection between this outstanding monies owed to TSTT and the quantum of workers who have been sent home? Can you share with us?
Minister of Public Utilities.
Mr. Vice President, yes, I can, and I will say emphatically, it has not impacted. This particular money, this company lost over $450 million in the first 6 months, of which there was a provision. Granted, there was a provision of over $300 million. But the company, even when you normalize the accounts with the provision, normalize the accounts, the company was had an operating loss of close to $100 million. Mr. Vice President, you cannot run a company, you cannot continue to invest and make the necessary types of advancements, especially when you're in a competitive environment, when you are losing money of close to $100 million operating profits. And that was an improvement from the 35, that was actually a situation that got worse from the 35 million operating loss that the company showed last year. So last full year, it was 35. This 6 months, it deteriorated to an operating loss of over 100 million in 6 months. If the company continued at that trend, the company would have been bankrupt in 2 years' time. And therefore, urgent action was required to save the 1,300 jobs that now exist in TSTT and to give the company a fighting chance for its survival down the road and to allow for it to be able to compete and make the necessary types of investments to allow it to be able to compete within the very competitive environment that exists.
Senator Mark.
Mr. Vice President, I would like to ask the Honorable Minister whether he's aware that this outstanding amount of money that we are yet to determine, can you share with this Honorable Senate whether there's a link between this outstanding amount of money and the decision on the part of the government to favor a particular English firm over TSTT for the provision of CCTV? Could you share with this Honorable House whether that is in fact a link? Why the thing has been outstanding? Truly, Honorable Vice President?
I won't allow that question. Last supplemental question, Senator Mark.
Mr. Vice President, can the Honorable Minister indicate, having regard to the bankruptcy or near bankruptcy that this company faces, can the Minister give this Parliament and this Senate a clear undertaking as to when this outstanding amount of money owed to TSTT by the government of Trinidad and Tobago will be met, will be satisfied, will be honored? Can the Honorable Minister give this Senate an undertaking as line minister through you, Mr. Vice President?
Minister of Public Utilities.
Mr. Vice President, I think I'll go back to my statement where I said that the services provided to the Ministry of National Security is not agreed. And therefore, and I further went on to say that it's currently being negotiated. At this point in time, there is a dispute between the services and the cost, and therefore these are being negotiated and discussed, all with a view of trying to ensure that the people of Trinidad and Tobago gets the best service at the best price, which is the ultimate objective that we are all attempting to achieve, whether it is TSTT, whether it is a privately owned company, service and quality of service and service for money paid is important that it happens. And this is what this government is ensuring that happens. And that's the process that we are taking.
Public Business, Government Business, Bill, second reading.
Before I call on the Minister, if, with your permission, we could revert to item 3 on the order paper. I am now in receipt of the instrument of appointment. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Paula May Weeks, ORTT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces. To Mr. Brian Bigg, whereas Senator Tahakwa Obika is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Paula May Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(b) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Leader of the Opposition, do hereby appoint you, Brian Bigg, to be temporarily a member of the Senate with effect from the 19th of February 2019 and continuing during the absence from Trinidad and Tobago of Senator Tahakwa Obika. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 19th day of February 2019. Honorable Senators, a senator is required to take the oath.
I, Brian Bigg, having been appointed a member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Public Business, Government Business, Bills, second reading.
Minister in the Ministry of the Attorney General.
I thank you very warmly, Madam President, as I beg to move that a bill entitled An Act to Amend the Trespass Act, Chapter 1107, be now read a second time. Madam President, the government proudly presents this bill cognizant of our duty to ensure the safety and well-being of our people in the face of the burgeoning criminal activity facing our country, and to guard against those among us who are intent on inflicting terror on law-abiding citizens. It is well established, Madam President, that the right of the individual to enjoyment of property is one of the most fundamental human rights and freedoms recognized in the Constitution of the Republic of Trinidad and Tobago. Section 4A of this Constitution affirms as follows, and I quote, "The right of the individual to life, liberty, security of the person, and enjoyment of property, and the right not to be deprived thereof, except by due process of law," end of quote. Alarmingly, however, Madam President, this constitutionally protected right has been consistently undermined by rogue elements in our society who are apparently intent on terrorizing and bullying private homeowners, tenants, and other persons in lawful possession of premises, forcing these law-abiding citizens out of their premises through the use of threats, intimidation, and sometimes raw violence, including arson. This is a nationwide problem which has affected people in our country, from Carenage to Toko, from Chaguanas to Cedros. In fact, in another place, we had examples, Santa Cruz, Manzanilla, Couva, in respect of this type of activity. It is against this backdrop, Madam President, that the Trespass Amendment Bill 2019 is now before this Honorable House. The bill seeks to address the untenable state of affairs which I have just described by introducing two new criminal offenses, namely forcible entry and forcible detainer. The bill also seeks to revise the existing penalties in the Trespass Act, Chapter 1107, to ensure that they are in line or brought into line with modern demands and expectations, and that they reflect the seriousness of the offense, which may be committed and are dissuasive in nature, a deterrent, in fact. Additionally, the bill will introduce new definitions and a section which will enable the minister to make regulations in order to give effect to the provisions of the Act. Madam President, the Trespass Act, which I will refer to in my presentation as the Act, became part of the laws of Trinidad and Tobago way back in 1852 and was last amended in 1936. In other words, 167 years has elapsed since its enactment, and 83 years has elapsed since the Act was last amended. But that only reflects, Madam President, that the business of trespass, the unlawful activity of trespass, is as relevant today as it was in 1852, which would have led to its enactment in the first place. Still very, very relevant. As we are all aware, Madam President, the law is not static, it ought not to be that, and it must constantly evolve and adapt to address changing social and sociological circumstances. It would have been impossible for legislators 167 years ago to envisage every scenario relating to the law of trespass which would require legislative attention in 2019. Therefore, while, as I indicated, the provisions of the Act remain wholly relevant today, we as a society are faced with a completely and totally unacceptable state of affairs and a level of criminal behavior which this government has demonstrated from its record and will continue to demonstrate we intend to address. The bill is a manifestation of this resolve. Madam President, having regard to the fact that the primary legislative initiative proposed in the bill is the introduction, as I said earlier, of two new criminal offenses to the laws of this jurisdiction, permit me to elaborate on the proposed offenses of forcible entry and forcible detainer. In considering the issues before us, Madam President, and arriving at an acceptable solution, several pieces of legislation, criminal legislation, were examined, because we didn't just run to the Trespass Act. We didn't just repeal the entire thing and replace it as some, since this has become a public issue, have proposed. We considered other criminal laws to see how we could address this burgeoning problem. The Summary Offences Act, Chapter 1102, was considered. The Offences Against the Person Act, Chapter 1108. The Larceny Act, Chapter 1112. After careful evaluation, however, it was determined that there was no existing provision in any of those laws which adequately addressed and criminalized the type of conduct that I have described earlier, Madam President. Madam President, with your leave, I will provide some examples which would illustrate the challenges faced in resolving this issue. This act generally criminalizes willful trespass. A, at night, in or about an enclosed yard, garden, ground, cultivated land, plantation, oil field, or refinery. B, on any lands at any time on which there is a fixed notice forbidding persons to trespass. And C, at a private wharf or landing place on which there is a fixed notice forbidding persons to trespass. At present, therefore, the Act, meaning the Trespass Act, does not treat with the situation we are seeking to address today. That is, where persons who are in lawful occupation of premises are forcibly and sometimes violently ejected from those premises with the use of force and threat of force sometimes, and are kept out of these premises. The Summary Offences Act was, as I indicated, also considered. Section 41 treats with instances in which a person is found on cultivated lands or found entering or leaving such lands without lawful cause or permission of the occupier of those lands. Additionally, Section 46D deals with persons who may be deemed to be rogues and vagabonds. That is, a person convicted of being idle and disorderly who is found, and I quote, in any veranda, gallery, passage, gateway, dwelling house, warehouse, store, stable, outhouse, or other building, or in any yard, garden, or other enclosed land for any unlawful purpose. It is also submitted that although these provisions in the Summary Offences Act do treat with the issue of being on lands and premises without lawful cause or permission, or for any unlawful use, a critical element to the issue to be addressed is lacking. That is, forcible entry onto premises and forcible detainer or keeping or holding or occupation of such premises. Madam President, just to give an example, the problem I've described do not only afflict private home owners and rent-paying tenants and what have you. It includes, of course, rent-paying tenants of state property, HDC properties. We've had a major problem in that regard. And recently, when the law enforcers had to treat with this problem in state property and had to go back a second time to remove persons who were previously removed, having to break locks on the second occasion, all that was available to law enforcement, the police with more specificity, all that was available to them was discharge in the Summary Offences Act, treating them as rogues and vagabonds. But that was not sufficient because they get bail, they come out, and they continue to operate. It did not address the problem of forcible entry and forcible detainer or holding on. Continuing, Madam President, Section 30A1A, Roman 3 of the Offences Against the Persons Act treats with the offense of harassment. And by way of veering off, just for the record again, this Offences Against the Persons Act was born, if I may put it that way, in 1925, well before our independence. It still exists today, very importantly. It's a major issue in dealing with some of our jurisprudence, and it is still relevant today. Notwithstanding its age, it continues to be on our books, and we have to handle it very gently. For the purposes of the section I have just quoted, which says, harassment of a person includes alarming the person or causing the person distress by engaging in a course of conduct such as entering property or interfering with property in the possession of the person, end of quote. At first glance, the offense of harassment is perhaps closest to the offense of forcible entry. However, harassment as set out in that section still does not treat with the issue of a person unlawfully retaining possession of premises. It is submitted, Madam President, that while persons who are at the risk of being forced out of their homes likely endure some form of harassment, it must be something more akin to harassment for the purpose of obtaining and retaining possession unlawfully, not harassment in those very general terms. And therefore, that law, too, has proven to be quite inadequate to deal with the problem as I've described it. The offense of burglary under Section 27 of the Larceny Act provides that a person who in the night breaks and enters the dwelling house of another with intent to commit an arrestable offense, or who breaks out of a dwelling house having committed an arrestable offense, is or could be found guilty of burglary. Unlike forcible entry and forcible detainer, though, this offense appears to refer to acts of entering and leaving premises, committing arrestable offenses, but it does not connote any intention on the part of the transgressor to take up occupation and to retain occupation of the dwelling house. Additionally, in order to be guilty of the offense of burglary, the person must have committed the arrestable offense at night. This provision, therefore, is limited in scope and is ill-suited to address the problem as we find it today. Madam President, it is clear that these major pieces of criminal legislation do not adequately treat with or provide a solution to the problem we now face. The safety, security, and well-being of the citizens of our nation is of paramount importance, and the government is taking steps that are necessary, all steps, to maintain law and order in the face of those who seek to destabilize and terrorize us. Madam President, in our quest to address the problem at hand, further examination of regional and international laws revealed that the offenses of forcible entry and forcible detainer exists in jurisdictions such as the United Kingdom, Canada, Western Australia, South Australia, Guyana in our region, and of course the Cayman Islands. By way of example, I will provide an overview of the relevant laws of 4 of these jurisdictions for the benefit of members of this House, so they would recognize that 1, it exists elsewhere, it's not unique, and 2, it is put in a way similar to the way in which we are treating with it, meaning, well, other people would have had to face this problem as well. In the United Kingdom, the first definition of forcible entry in law dates back to the 14th century. The Forcible Entry Act of 1831 now still exists in that regard. This act, together with its subsequent amendments, have since been repealed and replaced by the current offenses of in Section 6 and 7 of the Criminal Law Act 1977. Section 6 deals with violence for securing entry and provides that a person is guilty of an offense where he uses or threatens violence for the purpose of securing entry into any premises and knows that there is someone on the premises who opposes entry. Section 7 deals with the adverse occupation of residential premises and provides that any person who is on premises as a trespasser is guilty of an offense if he fails to leave those premises when so required to do. In Canada, Section 72(1) of the Criminal Code deals with forcible entry and provides, and I quote, that a person commits forcible entry when that person enters real property that is in the actual and peaceable possession of another in a manner that is likely to cause a breach of the peace or reasonable apprehension of a breach of the peace, unquote. Section 72, sub 2, deals with forcible detainer and provides, and again I quote, a person commits forcible detainer when being in actual possession of real property without color of right. I like the way that was put. Now let me read it again. A person commits forcible entry when being in actual possession of real property without color of right, he detains it in a manner that is likely to cause a breach of the peace or reasonable apprehension of a breach of the peace against a person who is entitled by law to possession of it. In neighboring Guyana, Section 312 of the Criminal Offences Act, Chapter 801, deals with forcible entry and provides, everyone, and I'm quoting, everyone with violence, who with violence makes an entry into any land or building, whether he is entitled to the possession thereof or not, unless he does so in pursuance of a warrant or other lawful authority to use the violence, shall be guilty of a misdemeanor and liable to imprisonment for 2 years. Section 313, 313 deals with forcible detainer and provides that everyone who, being unlawfully in or upon any land or building, maintains or attempts to maintain his possession or occupation thereof with violence shall be guilty of a misdemeanor and liable to imprisonment for 2 years. Madam President, in the Cayman Islands, the Penal Code at Section 84(1) addresses forcible entry and provides that a person who, in order to take possession thereof, enters land or tenements in a violent manner, whether such violence consists in actual force applied to any person, or in threats, or breaking open any house, or in collecting an unusual number of people, commits forcible entry. And Section 85, dealing with forcible detainer, says, a person who, being in actual possession of land without color of right, holds possession of it in a manner likely to cause a breach of the peace or reasonable apprehension of a breach of the peace against a person entitled by law to possession of the land, commits the offense of forcible detainer. Madam President, these 4 examples illustrate that the 2 new offenses of forcible entry and forcible detainer we propose to insert in our Trespass Act are not, as I indicated earlier, a novelty, but in our experience, it is a necessity because we know the pain and suffering that citizens of Trinidad and Tobago have suffered as a result of this. I can tell you I have had personal dealings with some of these matters. I've seen people leave Trinidad and go for a vacation to the United States or elsewhere. When they come back, they meet people in the house and they are told, don't stay here. I've seen cases where, Madam Speaker, a family member, like a father, dies, the children will not have been living there. When they show up to take control and possession of daddy's property, they are told by criminal neighbors, ride out, don't come back, and you have a stark choice. Either you come and fight for your property or you die. That's the choice they give you. I know of a case where a gentleman worked all of his life, used his retirement income, finished off a wonderful edifice, and he was chased out of the house by criminals in his neighborhood. He rented the house out, thinking at least as he adopted space in an annex in his sister's house in another community, he rented his house out. Within 1 week, they firebombed the tenant. The tenant had to flee, and then the house was taken over by such wonderful but unwelcome citizens of the Republic. Might I approach, Madam Speaker, Madam President, with your kind leave? Might I approach, Madam President, with your leave, a bit of a clause by clause? I don't think it's too necessary. This is as simple and straightforward as you can have it. But for the purposes of the record, I should venture very briefly an analysis of some of the short clauses in this bill. Clause 1, therefore, would provide for a short title to the Act. Clause 2 would provide for the interpretation of the words, the Act to mean the Trespass Act, Chapter 1107. Clause 3 would amend the long title to include the words and other premises. Premises is the new term that will be introduced in the bill for which a definition will be provided. Clause 4 of the bill would amend Section 2 of the Act to provide for the interpretation of certain words and phrases used in the legislation. Some of the new terms used will include enclosed yard, which would mean land that A, is surrounded by a fence or natural boundary, or a combination of a fence and a natural boundary, and B, is enclosed in a manner that indicates the occupier's intention to keep persons off the occupier's premises or to keep animals on the occupier's premises. Premises, which would include, as another definition, A, any lands, B, any building or structure or part thereof, whether permanent or temporary, whether fixed or capable of being moved. A very thorough application of the meaning of premises, I submit, Madam President. C, a dwelling house. D, a garden, ground, cultivated lands, plantation, oil field, refinery, or oil tank farm. E, any ship, boat, or vessel, because some people do live in those places, Madam President. And F, vehicles or aircraft, except while in operation. Additionally, Madam President, it is proposed that the definition of nighttime, which is defined in the existing Act as including any time between 7 o'clock in the evening of one day and 6 o'clock in the morning of the next day, be deleted. We are all aware that trespass, especially as I've described it, or trespass simpliciter, could occur at any time. So this terminology is not only archaic, but it limits the scope of the legislation and certainly does not assist us in what we are trying to achieve in this round of amendment. Madam President, Clause 5 of the bill would make 2 amendments to Section 3 of the Act. First, the words nighttime are to be deleted to expand the application of the legislation. Secondly, the existing penalty of a term of imprisonment for 3 months is to be increased to a fine of $50,000 and to imprisonment for 10 years, those reflecting the seriousness of the situation as I have described it, at least I hope I have, and of course, to have the effect of a deterrent. Madam President, I mentioned at the start of my short presentation that the bill will seek to increase the existing penalties in the Act to not only act as a deterrent, but to reflect the seriousness of the offenses which may be committed. Having regard to the fact that the offenses set out in the Act directly affect an individual's fundamental right to property and to the enjoyment of that property, and the right not to be deprived thereof except by due process of law, it is imperative that the penalties which are provided are proportional to the nature and the gravity of the offenses created herein. Madam Speaker, it is well known. Madam, I'm to apologize. Madam President, it is well known that the state can infringe the citizens' constitutional rights. The law books are replete with examples of that. And if the state is to acquire or to take or takes inadvertently even someone's property, the law and the Constitution insists that it cannot be so done unless by due process of law, and in most cases yielding compensation to the person who would have suffered that loss. And that is as against the state. But when the criminals intervene in the way I have described, there's no constitutional action against them. And as I demonstrated a while ago, the laws of Trinidad and Tobago, as they now subsist, do not affect them. So it meant that the police had to charge with some old law under the Summary Offences Act of rogue and vagabond. They pay $200 and they walk out and they go on, but they're not giving up the people's property. So it's that serious. Clause 6 would make 2 amendments to Section 4 of the Act. First, it is proposed that the word servant, which occurs in that section, be replaced by the words worker. I am sure that would be music to the ear of Senator Wade Mark, old but abandoned trade union activist as he used to be. He has now abandoned that. And we use the word servant. There was a criticism in the public domain that the word servant, it harks back to the old days, antiquated days. So we've changed that with worker, and I'm sure that would meet the taste of Mr. Mark, well, Senator Mark, a little more adequately. Secondly, it is proposed that the existing penalty of $200 be increased to a fine of $50,000 and to imprisonment for 10 years, where a person is found in any lands on which or near to which there's a notice forbidding trespass, or in the absence of such notice, where a person refuses to leave such lands when requested to do so. A rather unthinking citizen of the Republic, when this matter and this point became public, opined convivially and foolishly, in my view, that in this modern time, you have to put a stick with a sign saying trespass. Of course, it is noticed to the whole world. It existed then, it still exists now. In every country in the world, you put a notice on the land so persons will be warned, do not trespass. You can't do it by email, not everybody have that. You can't do it by WhatsApp, you may not have the offender's text number, phone number. So, notice to the whole world. So that's why I describe the intervention of the citizen as a bit foolish. But now that they are better enlightened, we'll hear no such thing, I am almost certain. So, Madam President, may I continue? Clause 7 would amend Section 5 of the Act in order to increase the existing penalty. Section 5 of the Act provides that a person who fastens a vessel, boat, or craft to any private wharf or landing place, or lands on which there is a notice forbidding persons to trespass, will be liable on summary conviction to a fine of $200. It is proposed, in keeping with the modernity that we now seek, it is proposed that this penalty should be increased to a fine of $50,000 and to imprisonment for 10 years. Clause 8 would amend the Act by inserting after Section 45 2 new sections, Sections 5A and 5B. Madam President, these 2 new sections would make provision for the offences of forcible entry and forcible detainer to deal with the problem as I've described it. And the proposed Section 45 will provide for forcible entry, in essence, where a person uses force, threats, or intimidation to enter property. And it says, and I quote, a person who uses force, threats, or intimidation to enter premises which is in the lawful possession of another person in order to expel that person and take possession of the premises, and does so otherwise than in the pursuance of a court or other lawful order. An order of the court or other lawful authority commits an offense and is liable on summary conviction to a fine of $100,000 and to imprisonment for 15 years. Additionally, Section 5B would make provision for forcible detainer, and it is presented, and I quote, as follows. Any person who, being unlawfully in or upon any premises, maintains or attempts to maintain his possession or occupation thereof, and does so by force or in a manner that would render the use of force as the only reasonable or practicable means of recovering lawful possession of the premises, commits an offense and is liable on summary conviction to a fine of $100,000 and to imprisonment to 15 years. Now, this is summary conviction, and of course, we know that when you outline in legislation sentences, proposed sentences like these, it is up to the court in any event to decide what sentence it would apply. And while it says and, it doesn't have to be both. And certainly for magistrates, if it's done summarily, would only be able to issue a sentence of 10 years. So it contemplates that possibility and indictment if necessary. Madam President, the term premises was inserted into the proposed section 5A and 5B in the other place. When we went to the other place, we had land and building. We changed that to premises in that place, and this was to enable the provision to have the widest application possible. Honorable senators will recall that the bill proposes to define premises to include any lands, any building or structure or part thereof, whether permanent or temporary, and whether fixed or capable of being moved. A dwelling house, any garden, ground, cultivated lands, plantation, oil field, refinery, or oil tank farm, any ship, boat, or vessel, or vehicles and aircraft, except while in operation. And this brings the question that particularly a layperson would ask, what is meant by lawful possession? Lawful possession, which is used in proposed sections 5A and 5B, it is intended that the term lawful possession mean in accordance with the law. Accordingly, lawful possession may include a person who has a proper title in respect of the premises, a person who has a tenancy or license to occupy premises, and a person who has even a certificate of comfort in respect to premises. All of those demonstrating that the person has lawful possession in respect of those premises. There are many variables which may affect the issue of lawful possession. And Madam President, it is for this reason it is respectfully submitted that to attempt to attach a fixed meaning to the term of lawful possession would be a disservice to the hundreds of thousands of citizens who may have a legitimate interest in respect of premises. Ultimately, where a question as to the right or title to any premises or any interest thereon accruing therefrom arises, it is for the court, based on the facts and circumstances in each case before it, to determine whether a person is in lawful possession or otherwise. Madam President, I have mentioned the persons to which legislation may apply. It may therefore be useful to also mention those categories of persons in respect of which the legislation will not apply. This would include tenants who fail to pay rent, tenants at will, and tenants who are holding over. In these situations, Madam President, there are remedies available which are already provided by law. So if a person entered premises as a rent-paying tenant, so to speak, and ceases to pay rent, that does not make him liable for the offenses we are creating here, because it cannot be shown that he entered using force or he was using force, well, unless, of course, he doesn't use force to retain it. There are other remedies against such a person in respect of his landlord. And there are other laws that govern that relationship. But just to put everyone at ease, it will not attack or deal with such a person because for obvious reasons. Madam President, it is also worth noting at this juncture that the provisions of the Act would apply to both private lands and lands belonging to the state. I alluded to that when I gave examples of HDC property earlier today. And I draw honorable members' attention to Section 6 of the Interpretation Act, which provides, and I quote in Section 1, no written law binds or affects in any manner the state or the state's rights or prerogatives unless it is expressly stated in the written law or it appears by necessary implication that the state is bound by the written law. And 2, notwithstanding the rights of the state are not affected that the rights of the state are not affected by a written law, the state may take advantage of its provisions. So that is an important point for note. Clause 9 of the bill would amend the Act by inserting, after Section 9, a new section which will enable the minister to make regulations, something we are all familiar with, to give effect to the provisions of the Act. And additionally, in order to circumvent the low monetary limit of $500 prescribed in Section 63(1) of the Interpretation Act, it is proposed that regulations made under this new section may provide that the contravention of any regulation constitutes an offense and may prescribe penalties for any offense not exceeding a fine of $25,000 and imprisonment for 5 years. So this formulation was done to circumvent the limitation of $500 that now exists in relation to regulations and their breaches in the Interpretation Act at Section 63(1). Clause 10 of the bill was inserted in the other place, which would seek to make a minor amendment to Sections 6, 7, and 8 of the Act by deleting the word servant, as I indicated earlier, wherever it occurs, and substituting that with the word worker. It was felt that this old connotation was not of any great value to us on this round. Madam President, the benefits to be derived from the measures proposed in this bill are, to the government's mind, invaluable. They will restore public confidence, at least in part, to the criminal justice system and serve as a deterrent to persons who may be career criminals or interested in becoming involved in that kind or other kinds of criminal activity. The bill sends a strong message to those among us who feel that they could manipulate people and flout the law for their own nefarious gains and are intent on inflicting terror on law-abiding citizens. And signals to them that this government is serious and will no longer allow that kind of lawlessness to prevail without lawful restraint. Madam President, when this matter was presented in the other place, and since then, the public who has had an opportunity to comment on it seem to have found great favor, because at the end of the day, they have been the victims of some of the issues I have described. And we feel very confident by that and our other anecdotal and studied evidence that these measures are very important, Madam President. And with those few words, I propose these measures for the consideration of this House. I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Trespass Act, Chapter 1107, be now read a second time. Senator Mark.
Thank you, Madam President. Let me welcome the Honourable Minister in the Ministry of the Office of the Attorney General, who after 3.5 years has found himself presenting a bill. I look forward to him assuming his rightful place as a veteran of the PNM and a full-fledged cabinet minister. A full-fledged minister, another minister in the ministry. Madam President, may I continue, please? I just wanted to welcome my colleague. Madam President, I want to make it very clear from the outset that the United National Congress, the alternative government of the Republic of TNT, is totally opposed to any criminal invasion and occupation of legitimate premises by citizens or owned or tenanted by citizens. And we will fully support measures to deal with those illegal occupants. So I want to make that very clear from the outset. But Madam President, I want to also advise this Honorable Senate that the road to hell, it has been said, is paved with good intentions. And I will demonstrate in my contribution, because, Madam President, I sought to get information as it relates to the drivers of this piece of legislation. We went to the police, we got some minimal inputs. We went to the judiciary, we got some limited inputs. We went to the Office of the Attorney General, we got no assistance. Because the Honorable Minister in the other place made reference to the Law Reform Commission. And we thought that would have been a useful document for all members of the Senate to have, so we could have understood, Madam President, what was driving this process. What data informed the government's policy on this matter? I think that's a weakness that we have today. And I must tell you, Madam President, just as how I missed your times, I missed the Attorney General. Because the Attorney General would have given us statistics and data. But we didn't get that today from our honorable colleagues. But, Madam President, may I indicate to you, as a government that is shortly to occupy office, we are in the waiting. I want to indicate, Madam President, that we have looked at some data that was supplied to us from the police. And, Madam President, unfortunately, we didn't get for the whole country. We just got for the Port of Spain division as it relates, Madam President, to threats of forcefully entering people's homes. And we saw for the period 2015 to 2018, there were 12 reported cases made to the Trinidad and Tobago Police Service in the Port of Spain. 12. 2015 4, 2016 1, 2017 4, 2018 3. So that is what we have before us, Madam President. In terms of trespass, between 2010 and 2018, we have 76, Madam President, and that is trespass by night. And as it relates to trespass of lands, we have just about 9. And that is for about 10, I would say 8 years, Madam President. So we don't have much data to go by as it relates to what is driving this particular piece of legislation. What we got from the judiciary, Madam President, is that from the period August 1st, 2013 to July 31st, 2018, the total number of persons charged and prosecuted at the magistracy was 437. And, Madam President, would you believe that the highest number wasn't in Port of Spain, you know? Separia Magistrates Court, 17.6%, and the Princestown Magistrate Court followed by 13.9% under the period, under review. So, Madam President, for the period 2013, 2014 to 2017, 2018, the average number of persons who were prosecuted, charged and prosecuted in accordance with the Trespass Act was an average of 87. That is what we are advised by the statistics received by the judiciary, Madam President. So, Madam President, I start off by indicating very early that when this matter of criminal elements invading and occupying citizens' homes in different parts of the island, I had raised a number of questions and sought answers. But I remember reading in the Newsday of Sunday, December 10, 2017, an article headline, Mitchell, anti-gang law could stop squatters. At the time, Madam President, we had an invasion of the Clifton Towers by criminal elements in that part of the island and the city. And the Honorable Minister of Housing at that time, Randall Mitchell, indicated that the anti-gang law could have been used by police officers to lay more substantial charges against those who had illegally occupied apartments at Clifton Towers in Port-of-Spain. None. But what I'm saying, Madam President, at the material time, we were being advised by the minister that those elements that make, again, forceful entry could have been charged not only under the Summary Offences Act, as my colleague said, but he made a very strong case for the anti-gang law, because these were criminal gangs that were invading people's spaces. So the question that has to be asked, why has the government not utilized the anti-gang law to deal with those elements, Madam President, who are occupying illegally our premises when we are not there? And when we go abroad, as we were told, and we return, our spaces are occupied by criminal elements. Why? But what we are being told, Madam President, is that we need to amend the Trespass Act. I want to indicate, Madam President, that in 2014, according to the research that we have conducted, there were 92 gangs in this country. And by 2017, under this PNM government, it mushroomed to 211 gangs. So the PNM, under the PNM, gangs have been multiplying and manufacturing under the PNM, Madam President. So what has happened, Madam President? Today, we are told, when you read the newspapers, we have close to 3,000 members in gangs. And Madam President, when we look...
Senator Mark, this bill that is before us is limited to certain issues. It's not about gangs, okay? So you can make your comment, but I'm not going to allow anyone to start off on something that is not relevant to the core issues of this bill. So I would ask you to move on, please.
Madam President, you know I'm always guided by your wisdom. Always. Madam President, I was not about to move on, but you know you anticipated me. But I'm moving on, Madam President. Madam President, I want to indicate very early, based on your advice, that the Trespass Amendment Bill is extremely disturbing, dangerous, far-reaching. As a Christian, I would tell you sinful. And I will demonstrate to this House, Madam President, through you, patently and manifestly unconstitutional and illegal. Madam President, this will end up in the courts of the Republic of Trinidad and Tobago. I will demonstrate why. And the government, it is either they believe that the opposition and the public are not conscious of the reality that surrounds us, or the government of this country is deceptive in what it is attempting today. I do not know which one to attribute to the government. Madam President. Madam President, we are dealing with two issues here in this piece of legislation. Criminal elements that we are saying we are in all fours with the government on that matter. But we are dealing with something else. Madam President. Madam President, may I invite you to go to the Colonial Act were the white planter class. Because those were the people who were in charge at the time. Laborers were like slaves, working for them. And servants, now workers, were also working for them. So in 1852, 167 years ago, we didn't have freedom as we have today. So, Madam President, we, in 1852, the framers of the law at that time stated, and I quote, the concept and definition of owner. Owner. Madam President, what did the definition says? It said includes a tenant, occupier, or other person having the possession. The possession, Madam President, the possession. And I will tell you what it means, what possession means of any land. You know what has happened, Madam President? I am a squatter. I am an occupier of land. I am now in possession of land. You know what possession means in the legal dictionary? The ownership, control, or occupancy of a thing, most frequently land or personal property by a person. So I am the legal occupier and owner of land right now under the Republic of TNT. But I'm a squatter. You know what this government is doing? Either, as I said, surreptitiously, deceptively, or unknowingly. They have now introduced, Madam President, the concept of what? Lawful possession. And you hear what the Honorable Minister said? Lawful possession means in accordance with the law. And he went on further to say, you must have title, you must have license, you must have deed in order to be in lawful possession. Madam President, let me let you know, under our Constitution, I want to quote section 6(1) of our Constitution. I am not a lawyer, but I read widely. And I leave it to the lawyers to interpret that, Madam President, including your good self, because I know that you're an excellent lawyer. Madam President, under 6(2) of the law, I wouldn't spend time regurgitating. You can go to the law, Madam President, and see what it means. I will summarize it for you. When you have a saved law, as we had in 1852, amended in 1836, and you are going to reenact that law with modifications, you cannot derogate fundamental rights. What the government has done in this legislation is derogated fundamental rights. So, Madam President, I have a right to property as an occupier. I have a right as a squatter. The government is now changing that and saying no longer possession, which I currently enjoy, Madam President, and anyone who trespasses on my land as a squatter, I can get rid of you. Don't come on my land. I have a right to that land. So, Madam President, what the government is doing, they have now introduced a new concept, Madam President, and they call it lawful possession. So, Madam President, what lawful possession means is that if I don't have title, if I don't have a deed of lease, Madam President, you know what that means, Madam President? You can now take my property. You can now take possession of my land. The state can now eject me from my property. Because we are dealing with state land here, I am not dealing with private property, because private property is part of it, Madam President. So, Madam President, I am arguing, and we are arguing here, that if you are derogating fundamental rights that I currently enjoy, you need to look at sections 4 and 5 of the Constitution. Because you are abrogating, breaching, and violating a right that I currently enjoy as an occupier. Madam President, what did the government say in this legislation? Madam President, the government is saying in this law, Madam President, that someone who is an owner includes the tenant, so it means lawful possession, the occupier, lawful possession, and other persons having the possession of any land. Madam President, so if it means lawful possession of any premises, and we have a new definition of premises, Madam President, in the legislation that includes land, building, dwelling house, garden, ship, vehicles. All of these things are premises. But, Madam President, before the government tampered with this provision and this definition, I had a lawful right. I had an inherent right to occupy property on state land. Madam President, what does this mean? It might be unintended consequences, but the government may not have thought it through properly. Because I don't believe, Madam President, that the government wishes to make unlawful those citizens, Madam President, who are in possession of state land in Trinidad and Tobago. And may I remind you, Madam President, from my research, there are 23,000 applicants who, before the 1st of January 1998, applied to the LSA for certificates of comfort. My information and research tells me that only about 10,000 would have been successful. So 13,000 would not have been successful. Madam President, since 1998, 1st of January, closing date for late application was 2,000. My research points me to 40 to 50,000 more persons have occupied state lands from then, from 1998, 2000 to 2019. Madam President, when you take 50,000 or 40,000, whichever number you wish to use, and you add another 13,000, we are talking about close to about 53,000 people. Multiply that by 4 on a conservative basis. Husband, wife, 2 children, and I'm being conservative, Madam President. Because you know in many families today, it's 5 and 6 children and husband and wife. That is something in the average in many areas today, in Trinidad and Tobago, especially poor areas. Madam President, we are talking roughly, if we are talking about 50,000 people, we are talking about close to 200,000 people. And in some instances, close to 240,000 people. So, Madam President, I am asking the question, Madam President, if you are proceeding...
Point of order, 46-1.
No, I'm dealing with a matter that deals with ownership, Madam President.
You're talking about squatters. Come on.
I will allow you to bring your point together, but you need to do that, Senator.
Yeah, all right. Madam President, if you look at the legislation, it is very clear, and I don't know why the government is jittery on these matters unless there's an ulterior motive. Madam President, if I take you to Section 8 or Clause 8 of the Act, and you look at 5B of the Act, Madam President, what does 5B tell us? 5B deals with forcible detainer. It doesn't deal with forcible entry, which is a criminal element. What it deals with, Madam President, is forcible detainer. Hear what the government is saying here. And I want the Honorable Minister to explain to the country, because I want to tell you, the United National Congress will be going to every nook and cranny of this country to deal with this piece of legislation. Madam President, hear what is being said. Any person, explain this to the country, Madam President. I know, but you know it's important. When we are speaking here, always remember, Madam President, the public doesn't know about this bill. So sometimes you need to share with the public what this thing is about. And remember, we have to educate the people, and it's about transparency. So I wouldn't deal with the entire thing, Madam President. But the point I'm making is that this part is saying that anyone who is unlawfully upon any premises and they maintain or attempt to maintain his possession. So, Madam President, I am on premises, land. I am seeking to maintain my land. I'm in occupation. And they're saying I am doing so by force or in a manner that would render the use of force. So, in other words, somebody is going to apply force to me, Madam President, as the only reasonable or practical means of recovering lawful possession of premises, commits an offense and is liable on summary conviction, Madam President, to a fine of $100,000 and to imprisonment for 15 years. Madam President, what is the government attempting to do in 5B? You are saying to an occupier, Madam President, that if you are in possession of property, the government has the power to use force if it's necessary to regain their property, because they're saying it is unlawfully being held, Madam President. And if it's being unlawfully held according to Section 5B, it means to say that the person doesn't have title and doesn't have license and doesn't have a deed of lease. So in those circumstances, Madam President, the government could use force to get people out of premises, Madam President. Madam President, I would like to advise this government that this provision of 5B is very, very dangerous. We are going to propose sweeping amendments to this piece of legislation to ensure that the rights of people are protected under this legislation. That's the first step. That's the first step. But we know it's a simple majority. Yeah. This is a simple majority. And the government may want to railroad their way. We would want them to withdraw this bill, Madam President. All right, sorry, Madam President. I am anticipating, and I shouldn't say that. I agree with you.
So you withdraw it, Senator Mark?
I withdraw it humbly and graciously, Madam President. Madam President, I want to indicate to this honorable House, Madam President, that this provision that I've just read, along with the definition, Madam President, is going to infringe on the very concept that the Honorable Minister spoke to, the right of every citizen to enjoyment of property and the right not to be deprived thereof except by due process of the law. But what the government is doing with a simple majority that requires a special majority is changing the goalposts, Madam President, shifting it from where I was in terms of enjoyment of property and saying, listen, you now have to have lawful authority and lawful possession. And if you don't have lawful possession, I, as the landowner and the landlord, the state, has the right to come and eject you. That is what, Madam President, this is attempting. And, Madam President, if you look at Section 4A, Section 4B, Section 4D, G, H, I, and J of our Constitution, rights are being infringed and rights are being violated by this measure. And I call on the government, Madam President, to withdraw this 5B, which is extremely offensive and oppressive and is not designed to bring about the kind of justice to those citizens who really deserve that, Madam President. So that's another area, Madam President, I would like to bring to your attention. Madam President, I also want to bring to your attention a measure that I find very disturbing. Here it is, the government is seeking to make regulations to deal with land and invasion of people's property. But under clause 9A1 of the bill, the minister is going to be doing that secretly. Meaning, Madam President, we are dealing with primary legislation today, and the minister is going to, the executive that is going to make regulations through a negative resolution. We have to go and look for that in the Gazette, and if you want to annul it, come here within 40 days after they issue it in order to file a motion to annul it. Madam President, since we are the lawmakers of this country and we have to keep a check on executive power, we have no choice but to call for an affirmative resolution. So we are calling on the government, Madam President, to change that from a negative to an affirmative, Madam President. Madam President, if you go to 9A2, I understand in legal language, and my friend Senator Ramdeen can advise on this. There's something called Henry VIII clause. And I get the impression, Madam President, that this is a Henry VIII clause. I have never seen such in my life. Madam President, they are asking us in the Parliament to literally buy cotton bag. Could you believe that? The government is so desperate to make regulations to deal with the 300,000 persons in this country who are going to be affected by this legislation that you know what they are proposing, Madam President? They are telling the country, Madam President, that they are going to prescribe penalties now, fine including $25,000 and imprisonment for 5 years. Madam President, how can you, without us as a parliament, having sight of those regulations, how can we agree as a parliament to give you prospective power? This is what I call a Henry VIII clause. You want to do things behind the back of the Parliament, but you come to the Parliament for approval today. Well, Madam President, we are not in support of this. Madam President, I want to also share with you some of the opposition concerns about these fines. I understand my colleague to have said during his contribution that these fines, as far as he's concerned, are very proportionate. Very, very proportionate. So in the years gone by, Madam President, the planter class seemed to have been a little more compassionate. $200 in 1852. In 1936, $200, Madam President. The Parent Act, if you go to the United Kingdom, Madam President, where many of these provisions would have come from, they do not go beyond 3 months. Do not go beyond 3 months in terms of imprisonment, Madam President. Madam President, do you know, in Trinidad and Tobago, I do not know, and the minister did not explain to us the rationale. All he said, it will serve as a deterrent, Madam President. So you're going from $200, Madam President, to $50,000. You're going from $500 to what? $100,000. You're going from 3 months to 10 years. Something is disproportionate, Madam President, about this. And the government has offered no explanation for the rationale for this kind of disproportionality. So, Madam President, I did some research on this matter, and I was able to come up with, now remember, Madam President, there's a concept called simple trespass. And this is what we are dealing with here. And then there's something called criminal trespass. Madam President, do you know that as it relates to summary offenses in the courts of Trinidad and Tobago, criminal charges and offenses, Madam President, you know if you inflict injuries with a weapon, you get 5 years in this country? But somebody who is in occupation, Madam President, and Madam President, I'm saying over and over, we are not in any way diminishing the importance of criminal conduct in this matter. What we want to do, Madam President, is to be fair and even-handed in what we are doing. And we as a parliament must have a rationale, and we must be able to justify, Madam President, why we are doing what we are doing. So, Madam President, robbery, I'm seeing you have a maximum of 6 years. Larceny, 5 years. Drug possession, 5 years. Firearms, 8 years. Statutory rape, 5 years. Indecent assault, 5 years. And I can go on and go on. So I'm trying to get from the Honourable Minister, could you share with this Honourable Senate, what was the rationale for these sentences, or these sentences, Madam President, in terms of the fine, 50,000 and 10 years? And secondly, $100,000 and 15 years. Madam President, is that going to be a deterrent? My colleague would have told you somewhere else that to kill somebody in Trinidad and Tobago, the sentence is death by hanging. Does that deter people, Madam President? So we have to be very clear in what we are doing. Because at the end of the day, what you want to do is to rectify a challenge or a problem that we are dealing with in Trinidad and Tobago, Madam President. And therefore, I am suggesting to the government, Madam President, that there are many areas in the current...
Senator Mark, you have 5 more minutes.
Yeah, Madam President, in the current legislation that is before this Honourable House, we are suggesting to the government that they revisit certain fundamental areas of the legislation. So the first thing that we are suggesting to the government is that we look at the whole concept of owner. We are not in support of the new changes that the government is proposing in terms of owner, having regard to the changes that it will bring. Madam President, I looked at the Jamaican legislation, and they had amendments in 1983. And they looked at both nighttime crimes and daytime crimes. And in Jamaica, they actually impose higher penalties in the night for crimes committed than in the day. Now, my colleague said, well, look, we'll be wasting time if we do so. I believe that it is something that we need to examine, Madam President, and not simply dismiss, whimsically. So I call on the government to look at the Jamaican legislation as it relates to this matter of fines in the day and fines in the night, Madam President. Madam President, we believe, and unless the government can prove otherwise by the recommendations that we are proposing in terms of the amendments, we believe, Madam President, that right now in Trinidad and Tobago, there are tens of thousands of citizens who are in the rain and they don't have a shelter. It is the role of this parliament to ensure that they continue to be protected, Madam President, and not left in the cold. And therefore, we have to refine the legislation to ensure that the thousands and hundreds of thousands of people who could be caught inadvertently in this legislation because of how it is crafted, Madam President. We need to craft legislation with more precision. Madam President, why are we leaving it up to the court to determine lawful possession? Why can't we not, as a parliament, determine that? Why are you leaving that for the courts? Madam President, you know ordinary people who are unable to build their homes and they have to occupy state lands. You know the kind of challenges that they are faced with. Madam President, you would also appreciate that if you have applied for a certificate of comfort and you are still awaiting that certificate of comfort, what is going to happen to you in the interim if somebody comes and seeks to kick you out or off your land and you go to the police, Madam President, for protection? Under this law, the police will ask the question, Madam President, where's your title? Where's your certificate of comfort? I have no evidence to show it, Mr. Policeman. Well, I can't protect you. So, Madam President, I want to also tell my colleague from Tobago, Senator Nigel De Freitas, the Vice President, that in Tobago, 95% of the people of that island don't have title. They don't have title. Madam President, it is possession and succession. They have possession and they also have succession, Madam President. So at the end of the day, you might call it irrelevant because you haven't studied the bill. You haven't studied the bill. But we have done our homework, Madam President. So she's totally out of order. I'm the Honorable Minister, temporary rather, Minister who will be out of office shortly. Yeah, you go and you get a lot of VAPs and thing recently. VAPs I'm talking about. Yes. Yes.
About 15 seconds. Please
Yes.
wrap up your contribution.
Yes, I wrap up, Madam President, by asking you, Madam President, clearly, we will not be supporting this legislation in its current form. We will be putting forward amendments to it, and we are hoping, Madam President, as you have predicted, good sense will prevail, so we won't have to end up in the courts of Trinidad and Tobago to defend the rights of the ordinary people of Trinidad and Tobago. I thank you very much, Madam President.
Senator Vieira.
Thank you, Madam President. Just to say through you, how happy I am to see Minister Hinds in this chamber again. I very much enjoyed his presentation, and I wish to compliment him on it. Madam President, it pained me when I heard about how people were being forced out of their homes. You know how terrifying it must be for an elderly person or for a single mother with children to be the victim of a home invasion. For the sanctuary of one's home to be invaded by fearsome, dreadful characters, probably wielding knives, cutlasses, and guns. Home invasions can be accompanied by robbery, rape, and violence. The purpose of this legislation, as we understand from the Honorable Minister, is to tackle those rogue elements intent on terrorizing and bullying homeowners into forcing people out of their homes. It sounds like something out of the movies, you know, the Walking Dead series or Bird Box. Yet this has happened in our country. Senator Mark has said that between 2015 and 2018, there were 12 reported cases in Port of Spain. Well, I want to say that's 12 cases too many. This legislation is intended to curtail what I could only describe as acts of barbarism and to provide victims and law enforcement with a user-friendly,
readily accessible remedy. Since Roman times, the law has regarded the home as sacred. Quid enim sanctius. What could be more sacred than one's own home? And in English law, the expression, the well-known expression, that a man's home is his castle, recognizes the right for people to feel secure in their homes is fundamental. Home invasion is the unlawful entry of someone's home, usually involving some type of force. Usually the residents of the home are present, but even if they aren't at home, entry is still unlawful. This legislation will fill a gap in the much-needed protection offered under the current law. As we have heard, the Trespass Act came into effect in 1852 and was last amended in 1936. But that act was more concerned about the rights of landowners rather than homeowners. And to be actionable, it required a notice in legible letters forbidding all persons to trespass, or, in the absence of such notice, a failure on the part of the offender to leave after being requested to get off the land. Of particular significance is Section 9, which preempts magistrates from determining any case of trespass in which any question arises as to the right or title to any lands or to any interest in them. So, where a defendant can raise issues pertaining to disputed rights, title, or he claims to have an interest in the property, the magistrate has no jurisdiction. Additionally, and notwithstanding that the essence of a home invasion or forcible entry is an illegal act, a victim may be unable to get support from the police if they take the view that the complaint is a civil matter. Right? And even if the police want to help, as we have heard, there are gaps in the law treating with forcible detainer and harassment and the like. Now, there is also the matter of self-help. Assuming that the victim is physically able to resist and overpower his or her attackers. But again, here again is potential for risk and negative blowback if the powers that be take the view that the force used in repelling the home invaders was excessive. Unlike some states in the United States, our courts, like the British courts, have frowned on the use of self-help, and in fact, they actively discourage self-help as a remedy. So then, what about going to the High Court? In terms of civil remedies, trespass is recognized as a tort, a civil wrong. But the problem is that having to bring proceedings under the civil proceedings rules, including drafting, filing, and serving the claim with the necessary evidence in support, then you get your hearing dates, and having to retain lawyers can be expensive and difficult. There are summary procedures available, though to the dispossessed homeowner, the word summary and summary relief in terms of process and procedure is relative at best. In any event, in the High Court, there are procedural hurdles and potential complications. For example, the fact is that courts generally do not like making final orders against persons who are not parties to an action. So being able to proceed for an order for possession against unnamed persons can prove problematic. Home invaders tend not to disclose their names or to give out cold cards. So, Madam President, the harsh reality is that the available remedies under the law at present are cumbersome, archaic, and oftentimes beyond the resources of the vulnerable. So I agree with the Honorable Minister that no existing provisions in the laws that adequately address this burgeoning problem. So I compliment the government for bringing this legislation. It will ensure that trespass to property can be dealt with firmly and swiftly. Rogues and vagabonds who violate personal privacy and security must suffer the consequences. Now, Senator Mark raised some concerns about squatters being on the receiving end of this legislation, and I understand his concern, but my reading of the legislation, it seems to me that those concerns might be somewhat misplaced or misconceived. I see this legislation not as a sword, but as a shield, right? So, in fact, a squatter who is in a dwelling house, and premises defines dwelling house as being a temporary structure, it's fixed, so it's capable of being moved. So a squatter could probably invoke this law under the doctrine of adverse possession, because his rights under adverse possession will not be affected. A couple questions and suggestions. Burden of proof. What must a victim show to qualify for police assistance? Should there be a reversible burden of proof on the accused to justify his presence in the premises? Also, at Section 5 of the Summary Offences Act, it is provided that where a person is charged with assault or battery on a child, or on a female, or upon any old, infirm, or sickly person, the magistrate, if in his opinion the assault or battery is of such an aggravated nature, can increase the sentence. Well, I like that provision. And I would certainly suggest and recommend that perhaps some similar provision can be included in this legislation. For example, if a woman or an elderly person are hurt or beaten up in the home invasion, prison time should be mandatory. I also wonder if it might be helpful to treat with conversion and trespass to chattels in the legislation. Conversion, as we know, is the taking of another's property, such as a crime of theft, but it extends to all exercises of dominion over property and includes the destruction of that property. The tort known as trespass to chattels would apply to lesser invasions short of taking the property. And last but not least, I don't think we have really dealt with Section 9 in the amendments, but let me just read Section 9 of the Trespass Act. Nothing contained in this act shall authorize any magistrate or justice to determine any case of trespass in which any question arises as to the right or title to any lands or any interest therein or accruing therefrom. I wouldn't like that to become a hurdle in the implementation of these clauses. Those points aside, Madam President, this is needed legislation, and I'm pleased to support it.
Senator Simonette.
Madam President, I thank you for permitting me to make a contribution in this very important amendment to the Trespass Act. Madam President, after having heard the Honourable Minister and my learned friend in the law of quite some time, Senator Vieira, there really is little that ought to contain and concern us in this debate further. But permit me, Madam President, to indicate why I consider that this bill is not only an important bill at this time in our country, but also that it does not offend or portend to any ulterior motive as contended for by Senator Mark. The Parent Act was passed just 4 years after the abolition of slavery. Let me repeat. The Parent Act was passed 4 years after the abolition of slavery. Subsequently amended in 1936 and remaining on our books untouched until now. But what is also important, and we will look at the ways in which the Honorable Minister and the Attorney General and this government has sought to modernize the law. But what is also of importance is that the civil remedy for trespass, as Senator Vieira was indicating, is not only likely to be and is unavailable to ordinary people, but if you know the law, the remedy is very restrictive. The civil remedy in trespass is available solely, and I would urge Senator Mark to listen carefully, to those who have title and ownership to land. Significant distinction. The persons entitled to the remedies under this bill do not have to show title to land. They have to be in lawful possession. And so Senator Vieira's point goes to the nerve of the mischief and the malady that exists today on the current law in relation to trespass. You cannot hunt with the hares and run with the hounds. If you have legislation that deals with gangs and gang violence and gang membership, that is specific to that issue. When we come to talk of, as Senator Vieira says, a man's or woman's home, which is their castle, we are talking about modernizing the law to enable ordinary people to have a recourse that is speedy and inexpensive to treat with the rogue elements in our society. That is what we're here about. We're not here about pantomime, about ulterior motive, and mauvais langue and old talk and juve morning about taking away rights and contravening sections 4 and 6 of the Constitution. We're here about delivering to ordinary people the very remedies that are now unavailable in our law. And let's get serious about that, Madam President. If we look, for example, at the proposed amendments to the definitions clause, and we look at the amendment to the dwelling house, Trinidad and Tobago is finally catching up to its sister, its big or little sister, as you may deem fit, Barbados. Dwelling house means any structure or part of a structure, whether permanent or temporary, and whether fixed or capable of being moved, which is designed or adapted for use as a dwelling or residence. So Senator Mark must understand what is true people's law, as opposed to the sophistry he engages in by trying to create the impression that this government is in some way against the people. This legislation is dealing with and delivers a remedy to owners of chattel homes. And if you, for the benefit of the listening public, a chattel house is a house, simple house, capable of being put on the back of a truck on a few bricks, but that provides shelter to persons who cannot afford better. And are those types of homes open to being vandalized, being entered upon unlawfully? The answer is yes. Did the 1852-1936 legislation deal with it? No. Has this government dealt with it? Yes. The other provision that brings this legislation into the modern era is the one that Senator Vieira alluded to and that I mentioned earlier. The traditional remedy is available to an owner. Here we look at a definition to occupier, and the definition indicates as follows. Occupier includes a person who is lawfully in physical possession of premises or has responsibility for and control of premises or the activities there carried on, so that the class or control over persons allowed to enter the premises. And what does that bring into being? That brings into being persons such as teachers, persons such as managers or agents of public property who are on public property with authority, etc., or on premises available or open to the public, thus expanding the categories of persons who are entitled to move for justice to be delivered in this circumstance of forcible entry and remaining in property where you have no right to so remain by deploying violence and force. Again, that was not or is not contained in the anachronistic legislation of 1852-1936. Madam President, again, as we were indicating, the definition given to premises is expanded. Not only are modest and temporary premises used as residences included, but the Act now also provides for security of agricultural holdings. That is, any gardens, grounds, or cultivated lands, not in the original legislation, not referred to by Senator Mark in his spurious ulterior motive spiel. So that what this legislation does, what this bill achieves, is providing remedies to the very farmers who are lawfully on their land, cultivating it, and who are raided and forcibly put off, where that remedy did not exist before. But further, we hear every year, whether it is a UNC government, whether it is a PNM government, the maritime industry, the marine industry. And what does the maritime and marine industry mean? We are the southernmost island in the archipelago, least affected by hurricanes, so that we have the possibility of providing safe haven to the yachting industry. What has been the recent experience over the last, say, 5 years? Piracy. People boarding yachts, whether in the ocean, whether the yachts are berthed in a marina, and stealing and doing harm and so on. What does the bill do? It defines premises to include any ship, boat, or other vessel. The old legislation dealt with that, but how did it deal with it? If you tied up your ship to the planters or the gentleman's wharf in 1852 or in 1942, without being invited so to do, then you were in trouble. That's how it dealt with yachts and boats, or boats and vessels. What we are doing here now is addressing specifically this not new, but burgeoning industry of piracy on the waters. What does the bill include in premises? Vehicles and aircraft except while in operation. I'm sure that Senator Mark has very many of his constituents who may be forced to live in their cars. Well, they now have solid and speedy recourse. Madam President, I wish to highlight that, and my learned friend, Honorable Minister, has dealt with the two offenses that are now new products of this bill. But what I wish to address is the fact that this bill in no way infringes upon our existing laws that protect land tenants or that protect squatters' rights. And may I indicate, Senator Mark helpfully indicated that since 1998, there were applications for letters of comfort, etc. Those letters of comfort, not issued in 1998, is not the be-all and end-all, Madam President, of the protection that such persons enjoy under the law. Our law still recognizes adverse possessory rights and title. And I repeat, adverse possessory title. If those on the other side have deeper experience in the other areas of law, certainly in the area of land law, I urge them to get a little counsel. Adverse possessory title is required after 16 years of uninterrupted, undisturbed possession. And it's referred to also as prescriptive rights. But more importantly, we have still on our books the Land Tenure Security, the Land Tenants Security of Tenure Act. And that act was specific to provide certain significant property rights to persons who prior to 1981 were in occupation of even private lands. And I need not go into the details of that act, but in summary, it entitles such persons to acquire either a 30-year statutory lease at what is a very reasonable rent, or to call for conveyance of such lands at half the market value. So let's be clear about this issue of ulterior motive. This law, this bill, is not addressing any of those issues, which on our statute books today, and which at common law protect the people that Senator Mark would like to believe this government is moving against. No such thing exists. It is an irresponsible, unmeritorious, lacking in content approach to what is a required and necessary intervention to treat with rogue elements at this point in time, where, Madam President, if I may say so, it left untouched, left unaddressed, it is the criminals that rule and we that follow. That must stop. Madam President, the other issue that I wish to address is the issue of the regulations. Now, again, if regulations are subject to negative resolution, there is nothing sinister, nothing underhand about that. That is responsible legislating. We come to deliver the remedy now, to deliver it in time where it is urgently needed, and we say, okay, in relation to related matters, the minister will make subsidiary legislation. Subsidiary legislation is always subsidiary. And so there is no cat in bag or ghost in the dark or knife in the chest or in the back that is coming at this. So let us be responsible and serious about the work we have to do in this chamber and limit the frivolity and the politicking. That's my solemn contribution on that issue. We have to deal with issues that are national. Let us put country first, as Mr. Vieira has done. Let us put issue first and deal in a mature manner with the work that the people have put us here to do and that they are paying us to do. And with that, Madam Speaker, I thank you and I beg to move.
Senator Ameen.
Thank you. Thank you, Madam Vice President. Madam President. Madam President, I want to thank you for this opportunity to contribute today in this the Trespass Amendment Bill 2019. And I have heard two speakers from the government bench, and I also had the opportunity to listen to those in the other place in the lower house. And it is my firm belief, I'm very convinced, that this government is so disconnected with the people and disconnected with the issues that how far-reaching the measures recommended in this bill could be to ordinary citizens. And I think it would help if they could be a little more receptive to some of the suggestions being put forward. Madam President, in recent years, criminals in Trinidad and Tobago have grown more bold. I think numerous speakers before me mentioned the criminal element, the gang element, and the government's lack of ability to really present a firm plan and a clear way to deal with crime, I believe, has a lot to do with that. And there is a perception in Trinidad and Tobago that, whether it is real or not, that there is a bold association with the criminal element to those in authority. And even to the effect where even ministers of government, that there's that perception. And that, Madam President, I feel has a significant contribution to how bold criminals in Trinidad and Tobago are becoming. And in fact, this government's only saving grace with respect to crime might be the appointment of a former People's Partnership Minister of National Security as their Commissioner of Police. The circumstances described by the mover of the motion, the mover of the bill, with regards to forcible entry, forcible detainer, his description tells me that he has a good appreciation of how violent these situations can be. But I also want to say, for those who may be mistaken, that these things can be experienced not only by the poor downtrodden squatter or the person who lives in a chattel home. It can be experienced by rich, poor squatters. It is not only people who are in NHA apartments in urbanized areas. It can happen in rural areas, north, south, east, west Trinidad. And I want to today share, Madam President, how I believe there are some unintended effects of the measures put out. The situation that we are trying to address is perhaps more prevalent than we think. We have not been presented with any data. I know the minister did indicate that he's guided by information or data, but we have not been presented with any data to indicate the prevalence of these situations. Because
I know it's early on in your contribution, but Senator Mark made that point already. And I do not want your contribution to be a repetition of what Senator Mark has presented. And he began his contribution by making that point. So I'll ask you to be very clear about the points that you want to make.
Thank you, Madam President. Madam President, I wanted to indicate, and it is supporting the point made by Senator Mark, but not repeating. And I want to add, we may not have data in terms of criminal reports because it is not an offense that could be captured by the TTPS reports on criminal activities. But based on social intervention and social work that is done, I feel that there are areas that we could capture data with regards to this type of activities. So I wanted to put that on record so that I don't know what source of information the minister would have, but that is an option to be explored. Madam President, because of where I live and because I associate with grassroots people all over Trinidad and Tobago, I am very familiar with the regularity to which this issue, you don't know where I live in, Brett, so don't tell me about grassroots. Madam President, the regularity of which this situation occurs does require the attention of the authorities. I recall that in the lead up to the 2015 general election, several PNM candidates indicated on their platform a promise in response to complaints, and it was mostly that I was aware of in the Port of Spain area. There was some in the Chaguanas area as well, where people were complaining, their potential voters and supporters were complaining of gang activities infringing on their ability to enjoy their home. And I think because they wanted to vote at the time, there was that campaign promise that going on the hustings and making and all the enthusiasm, making that promise so that the many voters affected by the criminal element taking over their property, whether it was in HDC developments, in squatter settlements, and so on, that they would be appeased. So in essence, this bill is really an attempt to deliver on a campaign promise. And unfortunately, this government is woefully short on achievements. So I think this is one of those fast fixes that they could count as an achievement if they pass this and put it on their platform as an achievement. Madam President, there are several categories of persons that will be affected. I know that Senator Mark spoke of the squatters situation. Senator Vieira also made reference. And I don't want the debate about this bill to go into squatter rights and squatter regularization only. The definition of owner in the bill the definition of owner in Section 2 goes to a person with lawful possession of any premises. And a squatter may be one such person who has difficulty proving lawful possession, but he's not the only category of person who would have that difficulty. Further, in E, the definition of occupier, which is a person lawfully in possession of premises, or B, has responsibility for and control of premises or activities they are carried on, or control of persons allowed on the premises. Madam President, this presents a difficulty that is worsened by the fact that the issue of land tenure regularization is not being addressed by the government. I want to deal with the squatter regularization briefly towards the end because I know others have touched on it. But Madam President, I also had some information on Tobago land situation, but I know Senator Mark touched on that. So I want to endorse it. But I also want to share with you, Madam President, that in Trinidad, the recommendations or the protection that is meant to in this act will not cover many persons. In the Tunapuna area, in Paje area, that area that is now known as Paje was the Bade Sagan Maraj estate many years ago. And it was agricultural plots rented to farmers who, after many years, built homes. When Bade's estate went to the state, they became tenants of the state. At some different points in time, they paid rent to the state. They paid taxes, land and building taxes, to the warden's office. At some different points, some of the residents would have been given leases by the government, agricultural leases. However, the area has developed to the point where it is no longer used primarily for agriculture. And I think of persons like the people of Paje who will have no protection under this act because some of them were never given title, although they would have been in occupation for 3 and 4 generations. I also know of situations like in Monroe Road, Chaguanas, where the occupiers of those lands were given state leases many years ago, 99-year leases, which expired. These people, they are not squatters, it's not poor rundown home. You're talking about people who, just as the minister described, a person who built up, invested his savings and built up their homes, good, respectable, law-abiding citizens whose 99-year lease expired. And they have not been given an extension of the lease or a renewal of the lease for a reasonable time. They, at present, have no title to the land. Are they in lawful possession? Are they considered a lawful occupier? Because when they go before the magistrate, it is not for the magistrate to determine who has lawful possession if that issue is in controversy. There are other situations like the Phoenix Park area. In Phoenix Park, you have lands that belong to Caroni 1975 Limited, and this is not only in Phoenix Park. There are other Caroni lands that Caroni 1975 would have agreed for persons to occupy. They were never given leases. They didn't have a proper rent agreement. They had just an agreement with the supervisors and with the company in general. And in fact, when I was chairman of Tunapuna Piako Corporation, we encountered a recreation ground in Spring Village where the land had belonged to Caroni in 1975. And by understanding over the years, it had gone to the regional corporation. So there are many parcels of land like that where persons would not have been given documents to say that they have title. My concern is with those people as well, or people who fall into categories like that as well. So the situation with squatters is one of the situation with land tenancy that needs to be dealt with. The Tobago situation, I think Senator Mark dealt with that, and I want to endorse his call with respect to that. And the truth is that the provisions in this bill will not cause, it may not cause harm to these persons who I'm talking about, but it certainly gives them no protection. And the prevalence of what we commonly call home invasion, or what is adequately described in the bill as forcible entry and forcible detainer, is pretty prevalent. And I think that the criminal elements are, as all of Trinidad and Tobago, the prevalence of information are becoming more informed. and they may very well know which properties they could target or which properties they cannot target. The squatter regularization.
You're not heeding my advice. You've spoken on it a little bit. It's not about the Squatter Regularization Act, okay?
Thank you, Madam President. I did say that I do not intend to make my contribution about squatter regularization, and I do hope that this debate is not about squatter regularization. I wanted to put on the record, Madam President, I did not intend to repeat what Senator Mark said. I want to put on record that the Squatter Regularization Act of 2000 came into effect under Basil Pandey as Prime Minister. There was an amendment in 2013 under Kamala Persad-Bissessar where the due date for occupation was, I think, July of 2013. So many people do not know that while initially the protection was up to 1998, protection for squatters occupying land is now up to 2013. We on this side have always advocated for the empowerment through land ownership and through home ownership. And I recall, in fact, part of my entry into politics had to do with the fact that the government at the time, the PNM government, Mr. Manning was the Prime Minister, they were on a serious campaign against squatters. They were demolishing people's homes.
Point of order.
Ameen, please, this is the last time I'm going to caution you. You are way off track. You need to get to the fundamentals of this bill, and you need to raise some points that really have not been raised before. You really need to get to the point of the bill, okay?
All right, thank you, Madam President. Madam President, I really am not getting the opportunity to get into the point I want to make. And it is not about squatter regularization. Madam President, I want to come to the issue, the social, underlying social issue. And I wanted to give context to the fact that the UNC has the history of standing on the side of the citizens, while the PNM has a history of demolishing people from their homes. And I'm providing that as a background, but I'm not talking about that.
Hold on. I have made certain rulings. You seem to be arguing about the rulings. I'm going to give you, and this is my last opportunity, last chance, raise some points that are relevant to the bill. You have given context, no more context. Raise points that are relevant to the bill, please.
Madam President, I will move on completely from squatter regularization and at the expense of neglecting some serious social issues that I would have liked to put onto the record. Madam President, though, I want to just address one matter that was mentioned by Senator Simonette. Senator Simonette, I know he made light reference and passing to persons who sleep in cars. And they are also a vulnerable group, even though it may be a small group of people. We are seeing more and more situations where persons who have recently lost their jobs, who cannot pay their mortgage and so on, and are sleeping in their cars with their families, and they too could become...
Sorry, I do apologize.
Point of order, Senator Simonette. Are you invoking a point of order? Are you in...
I'm not invoking a point of order.
Well then, all right. Listen, please, Senator Ameen, please. Senator Simonette, if you're not invoking, please, if you're not invoking a point of order, then you have to ask the senator if she will give way.
Did, Madam President. Sorry. Senator Ameen, would you give way?
I will, Mr. Senator.
Senator Ameen, Madam President, through you. Senator Ameen, I would not misquote you, and I think you may not have heard me. But the point I was making is that the bill, the definition of premises, gives specific recourse to persons who may be sleeping in cars, because it includes vehicles. That's the point I was making. I wasn't making light of it at all.
Thank you, Mr. Simonette. Mr. Simonette. Senator Simonette, if you had let me finish my point, you wouldn't have had the cause to interject to correct. I am actually supporting what you said. You said you made reference to persons who sleep in cars. And I am going further because you made light mention of it. So I am going further, Madam President, to indicate this situation with people sleeping in cars. And bringing this legislation and saying that these people will be offered protection because of the provisions in this legislation, Madam President. It is really a sad thing for this government to say that I am offering protection to people who have lost their jobs and are poor and hungry and sleeping in their cars. In the first place, Madam President, people in this country should not be sleeping in their cars. Yes. And that is an indictment on this government. So while I find it so sad that, you know, a member of the government, a senator on the government bench, could say, well, oh, hooray, we are offering protection for people who are sleeping in cars. Madam President, I also want to share a bit with regards to the clause that deals with vessels. The definition of premises to include several items, but with regards to E, any ship, boat, or other vessel. Madam President, only this morning, while on the way to Parliament, I think many senators may have encountered the fishermen from various parts of Trinidad and Tobago who are protesting for better fuel prices. But one of the issues that they identify as well is piracy on the seas. Recently, we had some fishermen who were kidnapped. They lament that because of, you know, environmental conditions and so on, they now have to go further out at sea and they are more at risk. The fact that very often even the vessels responsible for Coast Guard patrol do not have fuel to do the patrols that are required means that they get less protection. Because they go out further, 6-7 miles out into sea, they also encounter pirates with the illegal Venezuelan trade. And these fishermen are vulnerable. And while I see here that the premises would now include any ship, boat, or vessel, that would have an impact on the fishermen. But certainly, while the present laws still give them some protection, the issue here is the implementation and the government's ability to ensure that the coastal patrols are in fact in effect. So while the police has a responsibility to deal with the premises such as land, structures, buildings, gardens, and so on, where you have vessels on the sea is an issue. I got the impression, Madam President, that the phrase "except while in operation" applies only to vehicles and aircrafts, not to any ship or boat, all right, in E and F. So which is something that I would have had a concern over. So the protection of our fishermen and those who work offshore is something that I endorse, but I feel that it is not sufficient under this government. Madam President, I want to ask the minister who is responsible for bringing this bill and his colleagues, particularly when we go to the committee stage, that we be receptive. We have had some crosstalk and so on that seems to be making fun of the issues that we are raising. And I want to say that the experience of one person to another in this house may be different. The experience of the members of government, it seems to me, is very detached from the people, the ordinary citizen of Trinidad and Tobago. So even if it is something that you cannot imagine, let us give credit to the issues that are being raised so that we could pass good law. Yes. I am in support of the protection of all our citizens, particularly from the criminal element. But the government has much, much more to do in crime fighting and in addressing the needs of the citizens than what is being proposed here. Thank you, Madam President.
Singh.
Thank you, Madam President, for giving me the opportunity to present on this bill, an act to amend the Trespass Act, Chapter 11.07. Often, I'd like to say it's since 1852, this Parent Act was in existence. It's 160 years ago. And it goes to show that, since then, there was a problem of trespass. And the problem continues. It continues in society. We still have the elements existing. But we have some new factors coming into place. And not just in Trinidad and Tobago, but globally, because the Trespass Act in different countries was amended to actually give these old acts some more teeth. I was surprised by some of the revelations given, by members who spoke about the issue of forcible entry, which had happened in our past. We had mentioned certain areas where this occurred, and looking at the fact that it would mention that in Duncan Street, there was an issue where, on the Guardian newspaper, 2013, HDC and police cracked down on criminals. It was an August 9th issue where Nolan Sandy, he was forced to flee his apartment after a gang moved in and took over. So this was one of the issues, and when I read this, I realized the plight, how persons face there, they are paying for their apartments, and they are forced to leave. They are given this, this treatment by members of their community, sometimes moving in and actually forcing them out of their property, which they are paying for and quite rightly worked hard to get and, to try to keep. So that Duncan Street issue was just one issue. And in 2017, at Clifton Towers, it came to light that the, certain elements actually force persons out of their homes. And more so, not just persons out of their homes, but also HDC staff were actually forced from their offices. They were actually evicted. They moved. They were told they had to get out of there. So even those hardworking members of the HDC were not even protected in their own working environment. And up to this day, I still see one member who still has that trauma and that stress and was even thinking of suing the state for not providing a safe working environment. So here we have, it was mentioned by certain members, 11 instances over the past, I think over a short space of time. We have 11 instances. We have heard that it's widespread. Different places mentioned, San Fernando, Couva, HGC houses, all over in the country. We seem to have this problem occurring. And this bill seeks to somehow look at those persons in the HGC houses, which would actually look at giving the police, giving the government more control to take over or to, what I'm saying, recapture those homes, those apartments that persons moved into. These sometimes abandoned homes, sometimes actually forcing persons out of their homes. So in a sense, it's an excellent, gesture on the part of the government to see if this could somehow rescue these persons. But looking at the rescue of those persons in the HGC homes, we have to appreciate that ordinary citizens also face the brunt of persons moving into homes. Ordinary citizens will face that. And whilst we would want to help the HGC homeowners, we also have to look in the broader community, persons who look to police officers to help them get out of these situations, persons who are there looking for some sort of relief. And if this can give that relief, I will be in support of it. And I have just to mention that there was an incident recently in the community where I lived where someone entered a home, trespassed in it. We got the community security with some residents to hold that person. We carried that person in St. Joseph Police Station, and in a matter of 4 hours, that person was back in the area walking around, even though he was caught entering this home, even though he was carried to the police station. And, you know, when we looked at that, it was a failure. To me, it was a failure on the part of, hey, you know, why didn't the police act? I mean, there's the larceny act, there's you know, you breaking and entering, trespassing. All these, you know, we looked at, the police officers could have held that guy and give the community some sort of relief. And this is what we have to look at, the relief that the communities would want to get. So this was one instance where I was totally disappointed in the actions of the police officers. And the guy came back in the area, we held him again, and we carried him again this time back into the station. But this time, thankfully, he was charged and he is now serving a 4-year sentence. So we have to say, why did that fail? Is it that, I mean, he was, in my opinion, he was doing an act of trespass, he was there. And so why did that fail? And I'm thinking, if we can have any sort of laws to help our officers, I would say let us go after strengthening these laws. But then we also have to question what happened to the other laws. I mean, there are other laws that deals with trespass. The Larceny Act, Section 26, we look at burglary. But again, we have the question of if it's nighttime and whatnot, which is addressed in this law. We have even the Firearms Act speak of if you're going into an individual's home with a firearm. It also speaks a bit of trespass. So we have the trespass, the whole idea of trespass entering in different pieces of legislation, and even in the Summary Offences Act. We looked at Section 46D, where any person found in any veranda, passage, gateway, dwelling house, stable, outhouse, other buildings, a yard, a garden, an enclosed land, for any unlawful purpose, We looked at that, and we looked at this law, which is in 46D. Police can act on that. They can act under the Summary Offences Act, 46D. They can act to hold that person because, again, he is trespassing in somebody's property. Again, in Section 41 of the same act, it looked at any person found, in cultivated lands. So we're looking at lands and state lands in which there's livestock, farmlands. So again, it addressed the issue where some of our citizens who, PD larceny, you find that people are complaining, they're planting their crops, and so the Minister of Agriculture, would understand that these are the pieces of legislation which could help the farmers, because they have people working hard there, they have been given their sweat, trying to make an honest living. People are now trespassing in the land. So you have, again, in pieces of legislation there, people who are coming in without permission, in those lands there, the cultivated lands, you give them a fine of $2,000 or a maximum amount of imprisonment, 5 years. So if this act could now add on to this, if this act could somehow increase the penalties, I'm hoping that could somehow give those farmers a little more relief, or even give these homeowners who, you hold someone, they are in prison, at least if you can give them some more time in prison, if you could look at those persons who are breaching this act and give them some sort of punishment. Because you have guys, as I'm said, in that area. We took that guy to the St. Joseph station, but he came back in the area, and he came back into the same home. So somehow, we would have to be looking at the implementation of laws also. In terms of the Act now giving relief, giving more teeth, giving more sort of penalties to the farmers, I support that. But I also want to give an example, again, practical example. So while this Act will help the HGC tenants and help other persons, I'm thinking that real-life examples. I mentioned this case where there's a lady, 80 years old, where she rented her place, and the persons who rented the place stopped paying their rent and brought in other persons into the property. Then we realized there's a lot of illegal activities going there. This happens in Crep. It's a real-life case that's happening. And I'm trying to see if somehow this legislation would be able to help certain individuals, because there are individuals all over the place in Trinidad where you see people now use it as a way where they go into houses, they rent houses, they may occupy their homes, and they refuse to come out. And you find that even though this may be taken care of with the Tenants and Landlord Act, and they have redressed there in terms of distress. I've seen cases where people complain that you have persons in their homes and you cannot get them out. The police sometimes will come in and refuse to move them out. The police may come in sometimes and their hands are tied. And in this instance I mentioned in Crep, these people have occupied that home. They are trying to, even, when the lady is there trying to get them out, she has no recourse. So that is the difficulty she's having. And Senator Vieira mentioned the fact that sometimes the police come and they're in a dilemma, because the minute you come to a home, sometimes, you also have the idea of who really owns the home, in terms of the ownership. So that's an issue, again, that we look at. So the issue of looking at people moving into homes, renting homes, not moving out, and we have to create some way forward where we would be able to somehow, I'm thinking, if we could use this piece of legislation to help the population outside who are suffering in terms of they're too scared to report. And you see, so you may have cases there that if you report, those persons are going to come after you, and somehow if they're going to come after you, your family at risk, yourself at risk, and it's difficult. So all of these pieces of legislation, I'm thinking, will have to somehow be tied in to the Evidence Act or the bill that we are going to, I think we may be hearing that shortly, sometime in the future, where the anonymous reporting or giving an anonymous evidence may help cases like this, and even cases of the Trespassing Act, where it is difficult sometimes for people to come out and say, listen, this person is occupying my land, and they are scared for their lives. So this legislation has to tie in, I think, with other pieces of legislation, which I think could come to fruition shortly. So the need to protect is something, they need to be able to get the police officers to assist. All these are things we are looking at. And I even want to give a case recently where the Member of Parliament from my area, Mr. Prakash Ramada, publicly gave an account where he purchased land from the bank, a property next door, which was unoccupied for 2 years. And suddenly the police came with a previous owner, and they actually got entry into his property. They asked him for permission to go into the property with this previous owner who didn't occupy the place for 2 years. And they actually, in front of him, in front of the police, they actually allowed the previous owner with a gang of men who had guns to change the locks and took back possession. So again, here we have possession of a property which someone bought and legally, and in that case the police came, and the police there were allowed it to happen under their watch. And this serves the difficulty that, sometimes the police are faced with a dilemma. Who owns the property? Because, someone could come up and say that I have this piece of deed. Somebody could come up and say that I am the owner. And this is where I think that, part of this bill will fail in the sense that if it's delayed too long. And Senator Vieira made some sort of comments that, if there's not a way of getting this fast-tracked, you find people may be dispossessed from their property for sometimes 10 years, because some court matters, as we see, takes a long time. So imagine if you're dispossessed of your property and it has to go to court and it takes 10 years. To me, that's an injustice there. But then we have a dilemma here. How could we somehow fast-track this? Now,
Honourable Senators, we will suspend the sitting at this stage and we will return at 5 p.m.